Thank you, Frank. Thanks very much. And thank you all for being here. I think this may be the most people we've ever had at one of our open government forums. So I really appreciate your attendance. I think it's a testimony to how important open and transparent government is in this community. I am one of those people who makes it a habit of reading and rereading our state and federal constitutions. It'd be nice if more of our elected officials did that, right? One of my favorite passages is Section 32 of Article 1 of our state constitution, which talks about the importance of fundamental principles. It says that a frequent recurrence to fundamental principles is essential to the security of individual right and the perpetuity of free government. It's important for us to, from time to time, go back and reconsider those fundamental principles on which our state and our nation are founded. And so I would like to start off by talking about some of those fundamental principles of government. And since we're in Jefferson County, what better source than the words of Thomas Jefferson? If we look at the Declaration of Independence, the very beginning of it, it talks about self-evident truths, that all men are created equal, that nobody has a divine right to rule over us. Each of us has to be treated equally in terms of the relationship between government and the people. We're all equal in that respect. The second, that we are each endowed by our Creator with certain unalienable rights, and that among these are life, liberty, and the pursuit of happiness. Our rights don't come from the government. And whether you believe in a supernatural being or whether you believe that our rights are just inherent because of our humanity, our rights pre-existed the existence of government. But we, the people, established the government in order to help us protect our rights. And the government exists only to the extent that we give our consent to what it does. And the only powers the government has are derived from or delegated to it by the people. Article 1, Section 1, the very first paragraph of our state constitution makes this even clearer. It says, all political power is inherent in the people, and governments derive their just powers from the consent of the governed and are established to protect and maintain individual rights. If anybody ever asks you, what is the purpose of government? People will go and give you all kinds of things that government does, but the purpose of government is to protect and maintain individual rights. Now, the Declaration goes on. Lots of people stop reading at that kind of life, liberty, and the pursuit of happiness phrase. But the next self-evident truth, I think, is one of the most important. And that is that whenever the government becomes destructive of our rights, it is our right to alter or to abolish it. And if you read even further down, it says that we're very patient. It takes a lot to make us mad and to want to change the government at times. But not only is it our right, but it is our duty to alter or abolish the government if it becomes destructive of our rights. Now, we don't like to talk about abolishing the government. That's a rarely used tool. But altering the government is something that we do on a regular basis. We alter the government by voting. We change the people who are running the government. We pass laws directly, especially in this state. We do it on a fairly frequent basis. We try to avoid taking up arms to bring about changes in the government. There's this kind of famous analogy of our liberty standing on 4 boxes. Anybody ever heard about the 4 boxes? They are the soap box, the ballot box, the jury box, and the ammo box. We try to hope that the first 3 bring about the change we need. But how do we know what we should alter? How do we know what we should vote for? James Madison, the 4th President of the United States, put it this way. A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both. Knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives. The fact is that whoever has the most information is the one who's going to really be in charge. We see that in a lot of different ways, but in order for us to be the actual ones who are in charge of the government, we have to have as much information, as much knowledge as the government has. So how do we get that information? It is through open public records and open public meetings. There are three main laws that we use in order to get access to information about the government. I'll start at the bottom. RCW 4014 talks about the preservation and destruction of public records. It says that all records of government must be preserved forever, basically, unless some law allows them to be destroyed. And I'll talk more about the specifics of that in a second. The Public Records Act, once those records are preserved, the Public Records Act says that we the people have the right to access those records. And recognizing that not everything that government does is done in writing, but a lot of the work is done in meetings, RCW 4230 says that we must have access to open public meetings in order to know more about what government is doing. Frank's already read the preamble to both the Open Public Meetings Act and the Public Records Act. And again, the key point is that the people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. So let's talk about each of these laws briefly. RCW 4014 establishes the state archives. It establishes committees for both local records and state records that create what's called record retention schedules, which talk about how long each type of record has to be kept. Some types of records can be disposed of basically immediately. You know, the emails and memos about where you're going to meet for the softball game on Friday afternoon, right? Those kind of casual communications between government employees, or the phone slips and those sorts of things, basically can be disposed of as soon as their usefulness has ended. Other types of records, like vital records, births, deaths, marriages, those sorts of things, they have to be kept forever. And a very important part of government is just keeping track of who owns what. As you think about it, how do we protect our property rights if there aren't records kept of who owns each piece of property? And because marriages and those sorts of things have an impact on ownership, those things end up being kept forever. Typically, records are kept for 6 years. That's kind of the default if there's not another time period specified. It also talks about historical preservation. And there's a companion chapter, RCW 40.16, that defines the penalties for prematurely destroying records. And many people are surprised to find that it's actually a felony to destroy a record before RCW 4014 says that it can be destroyed. And when was the last time somebody was actually charged with a felony for prematurely destroying a record? I can't think of when that has happened. I don't know, Tim, if you can remember the last time a prosecution was done under 4016. Sometimes we think maybe it should happen, but that is what the law says.